Yes, Mr. Bates.
So, my lords, my lady, in the hour and a half maximum afforded to me now to take you through this, I wanted to try really and develop what I see as the two questions that are arising on this appeal. The first, it seems to me, is whether Section 79(2) is a consequence specified by Parliament which will always flow from a failure to comply with Section 78. And then the second is whether a landlord or some other party served with a claim notice, because it's not only landlords who get claim notices, can't rely upon Section 79(2). The Section 84(3) way of putting the question, as the Court put it to my friend this morning. I'm hoping to leave enough time in that second question about whether landlords can't rely upon the claim notice to deal with waiver. My own friend ran out of time, but I do want to deal with that because Ms Gibson is earmarked to deal with those submissions, so I will try and make sure I leave enough time to enable her to touch on those points. Turning then to the first question, and what Section 79(2) is doing. In my respectful submission, my learned friend started this morning from the wrong place. The starting point isn't policy documents or consultation papers. The starting point is the Act and the wording of the legislative scheme. So can we open up the relevant parts of the 2002 Act, starting at Section 71, which is on page 247. Now, I touched on this morning, but it seems to me we should start with Section 71, not merely because it comes first in the scheme of the Act, but because what it's doing in my submission is it's telling us that what follows subsequently is, as far as possible, intended to be a self-contained code. It makes provision for the acquisition and exercise of rights in relation to management of premises. It tells us how the company may acquire and exercise those rights. And it tells us in 71(2) that the rights are to be acquired and exercised and subject to in accordance with this chapter, and collectively they are known as the right to manage. 72 itself is the qualifying premises part. We don't need that for the present purposes. It simply identifies two broad categories of building to which the right to manage applies. You're either a self-contained building, or you're a self-contained part of a building. A self-contained building is one that's structurally detached, and a self-contained part of a building is one that meets the conditions in subsections 3 and 4, which are essentially, you can see a vertical division of it from the rest of the building. You could redevelop it independently, and its service media are already or could be made independent. Just pausing here for a minute, I don't agree with something my learned friend said this morning about claim notices being documents that are designed to tell you whether a building qualifies or not, because you can look at Section 72. Whether a building qualifies is actually capable of, depending on the facts, could be an incredibly factually difficult question. There'll be no way of knowing, for example, whether Section 72(4) is met just from a claim notice. That's a surveyor or engineer's report needed to tell you where the service media are, how they work, how they interrelate with other buildings, what you'd need to do to make them independent, etc. The next substantive provision to take us to is Section 78, which is on page 257. What Section 78(1) is doing is identifying categories of person who must be given a notice inviting participation. And the category of person is any qualifying tenant of a flat in the premises who is not already someone who has agreed to become a member of the RTM company or is already a member of the RTM company. The only requirement on Section 78(1) is that it has to be complied with before the giving of the claim notice. And it may be that you never need to comply with it, because it may be that there is no one to whom 78(1) applies. Because if you take a block of 2 flats, maisonette, if they're both in the company, there's no one to give a notice to. the notices can be served on different people at different times. All that matters is that if there is someone to whom it applies, you've complied with it as regards that person before you serve your claim notice, i.e. before the relevant date.
And Lord Snowden's point, what's the benefit to be acquired by the qualifying tenant?
So it seems to me there's a series of benefits that they may wish, that they may acquire. And if I can take you, my Lord, to our written case, page 72, paragraph 44. We could think of 3 reasons why you'd want to be a member of an RTM company at the earliest possible stage. The first is that because you're joining before the claim notice has been served, and you must be joining before the claim notice has been served because that's what 78.1 says, what you're getting by being a member of the company at that formative stage is the right to influence what the premises are that you're going to claim the right to manage over. And so what I mean by that is in the footnotes, a case called Evelyn Road, a Court of Appeal decision, where you had a row of terraced properties. And each of the individual parts of the terrace satisfied Section 72, but so did 2 of them together. So the 2 together could have satisfied Section 72, or each part of it could have satisfied 72.
Isn't there a sort of endless circle involved in that analysis? Because you don't know who the qualifying tenants are, do you, unless you know what the premises are over which you're going to seek to get the right to manage.
So the way it would fold is like this. Imagine, my Lord also had a question about the practical advantage. So a company has been formed, and it seeks to acquire the right to manage over 2 halves of a terrace. The people in one half may not want to be in a company with the other half, and by being given the opportunity to join earlier, they have the right to say that to the other people, to just say, look, I don't want to be managed by you. Even if you think you can somehow get the numbers, this is not going to be a happy relationship. We don't want this, it'll be difficult, there are practical problems, etc. So it's not quite the endless circle, the snake chasing its tail sort of problem there.
I can quite see the general point that tenants who haven't yet signed up may want to talk to their tenants who have and say, hold on a minute, we don't think this is a good idea. But what you were talking about was actually getting to the nitty-gritty of deciding precisely what the extent of the premises were.
Well, because until you serve a claim notice, you don't have to specify what the premises are.
No, but unless you know what the premises are, you don't know who the qualifying tenants are.
So you all join your company, so they join their company, and they say, this is an RTM company over these premises, let's say. But then they get a chance to talk together, all of them, and say, well, I don't want you to serve a claim notice over all of these premises. I want you to serve it over that configuration or that configuration. That's just one example. And it goes both ways, because it may be that actually what you want to say is, well, we have enough for our bit, but looking at it practically, we also need that building included. That third part of the terrace needs to be included, because that's where the satellite TV signal comes in from, whatever it may be. Because they're all in a company, before it's done anything to start the process of acquiring the right, they get to have the discussion about what is it they want to acquire. What do they actually want to do?
Does the RTM, does it have to claim the right to manage the whole of the premises?
So it has to claim premises to which the Act applies. If it claims that, and if the claim goes through by whatever route, it will acquire all the management functions as defined in the Act for that premises. It can't say, I only want the gardening and the external redecoration.
No, but can it say, I only want the flats on the 2nd and 3rd floors, not the flat? No. No,
it has to claim the whole premises, and then we'll see it, Section 96, it gets all of the management functions under the leases for those premises. And then, and only then, it can try and enter into negotiations with the landlord to contract functions back, but the starting point is it gets everything. So that's why knowing what your company is going to be is important in the first instance. Second practical point is our paragraph 44b. It gives the opportunity to influence the appointment of potential managing agents. And there's 2 points to make there, one legalistic and one practical.
sack them as soon as you can sack them as soon as you join.
Well, subject to paying any break payments, etc., if you can get the numbers. But it's because it's 2 points. When you serve the notice as an RTM company, you have to specify which agents you're likely to have. So you need to make that decision. Yes, you can look at the notices shortly. You have to specify who is proposed to be the managing agent. So being in the company at the beginning is really important, because if you don't want that company managing it, you need to be heard pretty damn quickly.
They have to be specified in the claim notice or the notice of invitation to participate?
It is the. I don't want to mislead, so let me just get the notice, get the actual notice in front of you. It is the. Sorry, I'm trying to find it. It's 205, thank you. 205 parrot. Oh, sorry, you put it in your one. Thank you, yes, it's the notice inviting participation.
Okay.
The notice inviting
participation. That's circular again too, isn't it?
Well, no, because it shows you why you need to be in at the beginning, because it shows you that actually a lot of decisions get made at the very, very earliest stage. And that's why people, to answer my Lord Snowden's question as put to me by Lord Stevens, these are the practical benefits you get. It's true as a matter of law that you can join an RTM company at any stage. But it's also true as a matter of law and common sense that if you join after important decisions have been made, you won't get a chance to be heard on those decisions.
But before the notice, the NIP lands on their doormat, the RTM company will already have had to decide who, in principle, is likely to appoint as the managing agent.
In principle, yes.
It's got to put that in the notice.
It puts that in the NIP, but you may want to be heard on that because you don't want that person managing. You may like RTM as an idea, but not that company.
But in fact, you can serve a claim form, can't you, without...
Yeah.
Sorry, an NIP in any event, without actually having decided on the managing agent.
Yes, I'd accept that. Yes, it's minded to at that stage because you haven't got anything to manage. You don't actually need an agent at that stage. It's minded.
So you say maybe in the NIP it may not, but it's an important thing that people would want to be heard over.
It's likely to be critical. The person who will actually be in charge of deciding who the cleaners are when the painting gets done, it's hard to imagine anything more critical when it comes to the management of your home. And then the third advantage that we could think of, going back to my Lord's question, is it seemed to us, it's our paragraph 44C, that of course if you're in the RTM company at the formative stage, you'll have a chance to be heard in relation to any of the negotiations that will take place with the landlord. So in A1, this court postulated a situation where you might have discussions with the landlord prior to the service of the claim notice. In fact, buying off was the slightly prejudicial term that was used.
It is slightly pejorative, isn't it?
It is, and I don't think that's what's meant by it. That's meant the practical reality of saying to the landlord, I've got the numbers, this building qualifies, I can take this over. There's a really difficult question here. How do we manage this, let's say, the fire alarm system on the roof? That's a really difficult one. It's really specialist work. Would you be prepared to take that back from us, even if we take control of the rest of the building? That's what I think the court meant by discussions about buying off. It's not saying turn a blind eye to the fact that you don't qualify at all. It's the practical questions as to how you will manage. And all of those discussions take place, or they should take place if you're running your company properly, at the formative stage. Because no one in their right mind wants to take over the management of a building with functions they don't want and can't get rid of. So that, my Lord, is just some practical questions there to go with the ones that were discussed earlier this morning. It may be you want to persuade them not to do it. It may be you think this is perfectly fine. But if you're not a member of the company, you don't get a chance to be heard at this formative stage. It seems to me it's not so much about the prescribed article.
How within 14 days do you get to be heard anyway?
Well,
even if you join, immediately you say, goodness me, right, I'd like to become a member straight away. 14 days doesn't give you really any time to do that, does it?
Well, it gives you time to join the company, And then what you can do within that time depends upon the reality of what the company is doing upon the ground. Imagine situations where it's a small building, block of 5, and they're all owner-occupiers.
No, but why 14 days? I mean, the legislature must have envisaged something that you were capable of doing within 14 days, or did it just pick 14 days out of the air because it seemed like a nice period? Because under most articles, we haven't got the articles, but under most articles, you wouldn't be able as a shareholder to do anything in 14 days.
Yes, they're not shareholders under these companies.
Sorry, a member of a company.
But unsurprisingly, again, we don't have the articles here, but I hope you'll take it from me, unsurprisingly, the management is normally done by directors. I think that's the point you're putting back to me, that a member simply doesn't get involved on that day-to-day basis.
It's not an Athenian democracy. I mean, it's run by the board like any other corp.
Like any other company, yes.
So that's force to my Lord's question.
Well, it comes to what... My Lord's question was, why 14 days? The short answer is, I don't know. Parliament had to choose a time, that's the time it chose. But the question I was asked was, well, what do you get from being involved at the earliest possible stage, given that you can join at any stage? And we thought of 3 examples.
It's 14 days, but by that time, the claim notice has not been served.
Correct.
So it may not actually be 14 days. It may, if somebody kicks up a fuss and says, I'm not happy with this, I want to discuss it further, it may turn out to be 6 months before the claim notice is served. I suspect it's a balance between not allowing obstructive tenants to stymie the process, but giving a chance for people to raise a bona fide complaint or point, in which case the claim form might never be served or might be served sometime later.
My lady, that's a better answer than the one I gave, and yes, I'd agree. It's inevitably... It's simply a consequence of the fact there has to be a rule and there has to be a time frame. What one does with it depends upon the facts of each individual case. Before I leave section 79, I just wanted to touch upon section...
I didn't actually got to 79. I thought we were on
79. Sorry, I'm still in 7. I've done 71, I've done 78, sorry.
Yes.
Sorry, I wanted to move. In section 78, I wanted to touch on 78.7, sorry, it's a question. This is the not invalidated by inaccuracy in the particulars. This was Lord Reed's example of the wholly misleading notice. And just to agree with Merlin and friends as to where the current state of authority, below this court, it must be said, but the current state of the authority is that the upper tribunal draws a distinction between an inaccuracy, typographical error and similar, and an omission, i.e. a complete failure to provide the correct information. And that's based upon Court of Appeal decisions under the enfranchisement legislation, where the same statutory saving provision is applied to certain enfranchisement notices under there. And I would agree with that.
It would be useful to know that, is that authority, don't go to it now, but to say where that distinction has been drawn in the...
I don't think we've got it in the bundle, but we can certainly send that in. Yes, I can think of the key one off the top of my head, both the upper tribunal level for this Act and Court of Appeal authority for the 93 Act. I'll arrange for that to be provided.
It's a rather tenuous distinction. I mean, for example, you have to state the names for members of the RTM company. So if you get one name wrong, that's an inaccuracy. If you omit a name, that's, I suppose, an omission. So, difficult to see why one is to be treated differently from the other.
Well, I say that's the divide the case law is currently drawn. None of it's at this level.
I thought it was more like an inaccuracy of getting one name wrong and just not bothering to put the names in at all.
And it might possibly be that it's different if you've omitted one of 2 joint tenants, so that you've got one of the joint tenants.
But what you're saying, the authorities have given everyone a little bit of wiggle room to find out if they just put Mickey Mouse, Donald Duck, whatever, then that's a bit more than an inaccuracy.
But even if you adopt that distinction, you can still have a NIP which is entirely inaccurate, and yet, as I understand it, under 79.2, you say that the failure to comply with 79.2 is potentially fatal.
A NIP which is entirely inaccurate. If every particular is inaccurate, section 78.7 on the face of it saves you.
Yeah.
Failure to give an NIP to someone who is entitled to receive one, and they're not already a member by the relevant date, is fatal, yes, because that's what section 79.2 says in our submission.
Not very rational.
What's the underlying reasoning behind that?
It seems to me that I'm not sure that I'd accept that it isn't rational, nor that there's no good reasoning for it. The NIP is serving its purpose by inviting people to become members of the company at the earliest possible stage. That purpose could still be achieved, even if there are lots of inaccuracies. That purpose, you don't know whether that purpose has been achieved or not, without knowing individually in each case whether the recipient understood what they were expected to receive. 79.2 is doing something different. 79.2 is saying that everyone has to be given the notice of this potential change in the management of their building before you can move to the next stage. What 79.2 is doing is preventing you excluding a group of leaseholders.
But on one view, that's what 78.1 is doing.
Well, 78.1 is identifying who must be served, and there may be no one who falls within that category. If there is someone who falls within that category, and they haven't been given their 78.1 right by the relevant date, 79.2 kicks in. That's our case on its facts. 79.2, as I said before, the short adjournment, 79.2 only kicks in if on the relevant date there is someone who has a right to join the company. Such right is to be communicated to them by reason of an NIP, and that hasn't been given to them at least 14 days previously.
I do apologise. I haven't quite grasped the reasoning behind the distinction between you can serve a NIP, which is inaccurate, but as soon as you fail to comply with 79.2, that is potentially fatal. What is the reasoning behind that distinction?
Because Parliament has made the decision that you must get something under Section 78. If you don't get something, you don't move to the next stage.
But the same consequence would flow if you only got it 13 days before. I mean, you say, yes, I think, that the same horrible consequence of it,
yes, it would.
Of, call it invalidity or not, flows, even if they did get it, but a day short.
And haven't joined the company, yes.
Yes,
Yes, I do say that. Yeah.
But I come back to my Lord's question about rationality.
Yeah, you get a completely accurate form 13 days before the relevant date. That's fatal. But a completely accurate one, a completely inaccurate one, 14 days before you're home and dry.
Well, inaccurate in the particulars. The particulars are the bits required by the Act. It's not inaccurate, for example, in respect of the notes, telling you what your rights are that come with the Act. But, my Lord, my Lady, I'm not shying away from this. We've said this in our written case, and I'll say it orally. The starting point is, what do the words mean? We come to Section 79.2, we come to that then next in the analysis. It means what it says. You start with 79.1. A claim to acquire the right to manage any premises is made by giving notice of the claim. Just pause there for a minute. We don't need relevant data. I don't think that's troubling the court. So a claim to acquire the right to manage the premises is made by giving notice of the claim. Sub 2, a claim notice may not be given unless each person required to be given notice of invitation to participate has been given such a notice at least 14 days before. It's a short point in our submission. That does mean what it says. May not be given. If it may not be given, it cannot be, to use the language of paragraph 94 of A1, a sufficient basis for transferring management. It may be a sufficient basis for going to the FTT to find out what the answer is. But a notice that can't be given can't have the effect of taking away someone's rights.
Why? It just says you can't do something. It doesn't actually tell you what happens if you do.
No,
it says I can't drive a car at more than 30 miles an hour outside, but it doesn't tell me what happens to me if I do.
So then we come to a question of interpreting section 79.2, and we've put in the authorities bundle 3 decisions of this court under different schemes, but where we say sufficiently similar reasoning sufficiently similar wording was interpreted to be the consequence that we say it should be in this case. So can I just take you to those? The first is the Shahid case, which is in the authorities bundle at page 1005.
1005.
1005, my lord, yes.
Okay.
Somewhat different context.
I appreciate context is different. I will come back to 2 decisions of this court about this particular statutory scheme, which we say also support our reasoning. But to pick up on my lord's question, it doesn't say the consequence. Well, this is, I accept, a very different context. This is a prison rule governing effectively segregation of prisoners. Page 1020, paragraph 15, the rule is set out. If I can just ask the court to read paragraph 15. The words shall not be subject to such removal except means that what follows is a precondition to the lawful segregation. Well, the same point can be made here. May not be given unless...
Was this in the context... I mean, I'm trying to remember now. Was this the context of an Article 8 of a Human Rights Convention?
There is a human rights argument that goes into it, but you started...
So there'll be a question about whether the interference with this right to private life was prescribed by law, if it was in breach of the prison rules.
But that is right. But as part of the argument about interpretation, it was being urged upon you that you could adopt a synergy analysis. I say you, this court, being urged upon this court that one could adopt a synergy analysis of those wording. And if you look at paragraph 20, the court rejected that. So the court approached it in the question of, well, what do the words mean first? And this court concluded there's no room for a synergy analysis because the legislation has spelled out the consequences. Now, it didn't use the words void, voidable, etc. You don't need to. It's always a question of statutory interpretation. So
in that sort of case, there's no doubt that the segregation takes effect as a segregation. The only question is whether it's unlawful and gives rise to remedies.
Yeah. So
this case is rather different.
I agree, but I'm relying on it for a different point. I'm not for a second pretending that the considerations that come into play when looking at detention of the subject are the same as apply when we're talking about transfer of management functions. It's really for the paragraphs 20, 21 and paragraph 15 point. It's the proper approach to construction of a statute. You start with the words. If Parliament has specified that this is the consequence that flows, then that is the consequence that flows. And no amount of purposive interpretation can save us.
As my Lord Snowden pointed out a moment ago, a difficulty you have is that whereas it's put in paragraph 20 of this case, authorities like Synergy are concerned with situations where the legislation is silent as to the consequences of failure to comply. Now, here, the legislation doesn't spell out what the consequences are of the, how's it put, claim notice may not be given. Well,
respectfully, my
but what follows if it is?
Respectfully, my lord, we say it does spell out the consequence, and that's the starting point in our submissions. If we're wrong about this,
That's what the Court of Appeal held.
yes.
But can we just test this again by reference to jumping the gun, a claim notice given too soon? At the moment, I can't see, if what you do is to give it too soon, there's any specification of what happens if you do give it too soon. It is genuinely silent. Whereas, if what you're talking about is a failure to comply with Section 78 so as to notify all qualifying tenants, then one can sort of see 79.2 as telling you what the consequence will be if you don't comply with 78. But you say that the consequences of either of those failures, that is, failing to serve somebody or jumping the gun, is the same.
Well, let me, I do say that, and let me just unpick why. In my submission, the way you approach this question is you start with section 79.1, which tells you the claim to acquire the right to manage is made by giving a notice of the claim. And we can put a full stop there because the rest of it doesn't trouble us for the purposes of this case. 79.2 then tells you the claim notice may not be given unless each person required to be given the NIP has been given one at least 14 days before. Our case is simple. That means what it says. If something cannot be given, 79.2, you cannot give it to start the process, 79.1.
Isn't that just the old directory mandatory heresy? I mean, what if the CPR says you may not issue a claim form unless 14 days before you've invited the other party to mediate? And let's suppose you only invite the party to mediate 13 days before and issue your claim form. I'd be surprised if anybody construed that as invalidating the claim form, although it may have some consequences in terms of costs.
Well, the question is always, my lord, what do these words mean? It follows 79.1, which is the duty which is you start the process by giving. It tells you circumstances in which it may not be given. In my respectful submission, that can be nothing other than, and the Court of Appeal were right, that is on its plain reading, that is the consequence that follows.
But there's
Now,
clearly an injunction not to give it. And but the question then is, what happens if you do?
It's not merely an injunction not to give it. It's a may not be given. If something may not be given, it cannot, in our submission, found a subsequent legal step.
Do you, if instead of 79.2 there had been 78.8, which had said the RTM company must not give a claim form under section 79 less than 14 days after giving everybody a NIP. And there hadn't been 79.2, there had just been that, which uses the sort of must not formulation, which generally has not been regarded as specifying the consequences. It's a classic formulation which prompts then a synergy analysis. So would you say that if it had been drafted in that way, that it was included in 78 and it was a prohibition on serving the claim form before everybody's had 14 days, if they're not members of the company, to join, would you also say it specifies the consequences, or is it something to do with the may not be given wording, which you says has more oomph to it, if I could put it like that, than the must not?
So I think I probably would still maintain that it was fatal, but I think it becomes a more difficult argument for me to maintain, because then a different point is taken against me. The point is, but look, it's moved places in the Act. It's moved out of Section 79 into Section 78. It's speaking to the Section 78 process, effectively, and I can see there's much more scope for a reading that wouldn't have the effect I'm arguing for now. It picks up on a point I think my Lord Snowden was toying with, arguing both for and against himself earlier this morning, just testing the proposition. Does it matter it's where it is in the Act? Well, the answer is yes, it comes straight after 79.1. 79.1 is you can't go any further. If 79.1 somehow gets deleted, the right to manage just falls apart, because that's how you give the notice, the claim notice. So if you can't get to 79.1 because of 79.2, that's the consequence Parliament specified. Sorry, my lord, I cut you off.
No, I was going to sort of move to a point, taking the point that the restriction is here in 79, as you say. If 79.2 had been phrased slightly differently, what would your answer be? If it had said an RTM company may not give a claim notice unless each person required, etc., within 14 days. In other words, if it had started by directing things at the RTM company, would your answer be the same?
No, I don't think it would, because you've still got to grapple with section 79.1.
Sorry,
it's 79.1 that's the important bit, because that's what they're trying to do. They're trying to comply with 79.1 and give the claim notice which starts their process. That's what they're trying to do. But then they're told they can't do it.
One of the things I'm trying to tease out is, one of the points I think that is made against you is that this is really just a timing provision.
Yeah.
And in fact, if you look at 79 subsection 3, subsection 3 talks about the substantive requirement that you can only give a claim notice if you are an RTM company which complies with 4 and 5. Now, just as a matter of drafting, I wonder whether what's actually happened here is that just for ease of drafting, the two requirements have been separated out. And it seems to me you place quite a lot of weight on the fact that 79.2 starts with the claim notice may not be given, as if that's essential to the validity of the whole thing. Whereas in reality, is it not just a bit of drafting technique? Because in reality, it would have been just more complex to direct it at a prohibition on the RTM company. Because that, if it had been drafted that second way, it's less obvious that it's, as it were, fatal to the whole start of the process. It's really just a direction to the RTM company which doesn't specify what the consequence would be if it didn't comply.
Well, if we're moving into the realms of advice to parliamentary council as to how they'd draft it if they didn't want consequences.
No, but it was really that I think you do place quite a lot of weight on the way in which the opening words of 79.2 read, as if it's fundamentally directed at the starting, initiating part of the process.
I do, my lord, and I'm not going to shy away from that. In fact, I'll place as much weight as it will bear on it's the word given. That's the important bit. In 79.1, we are told that the way you start an RTM claim is by, quote, giving notice of the claim. We're then told in section 79.2 that a claim notice may not be given unless. Well, if you start it by giving something, but it may not be given, you cannot have started it.
But if you say, then you look at 79.3, the claim notice must be given by an RTM company which complies with subsection 4 or 5. I thought you accept that the way to challenge the non-compliance with subsection 4 or 5 is for the RTM company to serve a counter notice under section 84.
I do accept that. For the landlord to serve it, yes.
So, I mean, to that extent, it's not invalidating what's happened, is it?
Well, it's the question.
It's just triggering. It's putting on the spectacles that.
It's not, my lord. This is where I started before the short adjournment. It all comes back to paragraph 94 of A1. Let us assume you have served a notice which is not bad on its face. It's not a notice to quit, let's say. They've downloaded the right form, sensible information has been provided in it. It looks to all intents and purposes like a claim notice. That claim notice is, in the words of section 94, sufficient and always sufficiently valid to engage the act. So what does the Act require then? Well, once you're given one of those notices, you're put to your election in Section 84. You serve a counter notice admitting, denying, or you do nothing. It's valid for those purposes. If you ignore it completely, you're running the risk that they'll be deemed acquisition. So you serve your counter notice denying. You deny it and you say, I allege that by virtue of Section 79(3), let's say, you are not entitled to acquire the right to manage, and then the tribunal will have to decide, did the NIP comply with those subsections? If it did, right to manage passes over. If it didn't, right to manage fails. It's...
Right, but you accept, so you say that 79(3) is a provision that can be specified in a counter notice as disentitling the RTM company from acquiring the right to manage.
Yes.
And I think you also accept that an inaccuracy, however one construes that, in the particulars, that's not a provision that disentitles the RTM company to claim the right to manage, and so it's not one that can be specified in a counter notice.
I can't see any other way of reading 79(7), no.
Right, okay, so what we're deciding is whether 79(2) falls in the first category or the second category.
And in our submission, it falls in the first category.
Right, and in their submission, it falls in the second category.
And we say, firstly, look at the wording. Giving and giving is important here. Secondly, we do say there's some benefit in looking at the Shahid case we referred you to. We also refer you in the written submissions. I've got one on the time, so I want to be a little bit
I
careful.
was just wondering whether or not you're actually putting words into 79(2). That is, the notice may not be given so as to transfer management unless each person required to be given a notice of intention to participate has been given such a notice at least 14 days before.
I'm certainly not seeking to put words in. I'm reading the statute in light of what this court said in A1 paragraph 94. If I'm wrong about that's what paragraph 94 means, then this argument...
Or it was overture and wrong.
Sorry, Mike.
94,
Oh.
you're talking about 69.
Sorry, paragraph 94 of...
Of A1 properties, the void...
Look
fact
at
that void is a very unhelpful way of
Sorry,
looking
I'm
at
thinking
it.
the earlier paragraph.
It can be...
Nullity is neither here nor there, given what everybody says is the effect of 90, the deeming, because you can't say, assuming that it's all the tribunal determines it, that's how you acquire the right to manage, or nobody objects, that's how you acquire it. Nobody's claiming that Parliament intended that at some time later it could all have to be unpicked because there was some defect that nobody then knew about in the claim form.
Can I just also check this? Is this a fair summary of what you say the claim notice does, its effect within the scheme? One is, in an uncontested case, it sets the commencement date of the new management regime. That's the relevant date.
Mm-hmm.
Yes.
Two, in a case that's going to be contested, it launches a procedure and confers jurisdiction on the first-tier tribunal to resolve that dispute. And three, and again only I think in an uncontested case where the landlord either agrees or does nothing, it leads to an effective scheme.
Yes, I think I agree.
It confers the rights of management. It triggers a process which it confers the right of management, albeit that right depends on the underlying entitlement conditions.
Yes, I agree with all three of those.
Right. But and I think you're asking us to read 79(2) as, if you like, disabling that last one, but none of the other effects of a claim notice.
Well, if it comes back to the point that if no one takes a point, the Act, then it doesn't get in front of an FTT, so the FTT won't take the point for itself. And so we come back to paragraphs 87 and 88 of A1. In those circumstances, it does transfer over. Yeah. And it may be that someone's thinking about clever answers in the High Court in due course. But I don't shy away from that. That's a reading that fits with what this court said in A1. I'm conscious that there's 15 minutes or so left. I wanted to take you through 5 cases, and I've managed one. So I'm going to give you some page references. I do say that there is some additional benefit gained in looking at how this court has on first blush read the statutory scheme, because this is now the third right to manage case to make its way to this court. And I say on each of the two previous cases, the initial reading of that court was as what we say it is. So the first in time was Settlers Court. I'll give you just the page references. It's page 545, paragraph 16, where we say this court again read section 79 as something that had as a prohibition on moving to the next step. If I can just give the court the references, I'm terribly sorry, but
545 paragraph
16, according to my notes here.
Yes, the second half of it.
Yes, thank you, my lord.
Yep.
The second is in A1 Properties itself. The reason, or one of the reasons, the court came to the conclusion it came to in A1 Properties, i.e. that there was no consequence spelled out for not serving a landlord, was in part because, of course, there's a deeming provision. There's a provision for applying to the FTT if there are absentee landlords. And so the point was that Parliament has envisaged scenarios where you couldn't find someone to serve a notice upon. That was an indication the notice on every landlord couldn't be a critical point, etc., etc. The point is the absence of any such scheme here. There's no way of getting round the fact that you have to serve all the qualifying tenants. There's no exception for them even if you can't find them. Now, my learned friend says that's a point in his favour because that's really hard to comply with. How do you deal with the 1,200 block of flats? Can I just give a very short answer to this one? Because I do think this is the answer to this point. In the 2002 Act itself, can you go to section 111, which is at page 302. This is a provision for notices under the 2002 Act, and you'll see at 111 sub 5, the company which is an RTM company in relation to premises can give a notice under this chapter to a person who is a qualifying tenant of a flat at the premises unless it's been given some other address. So service at the flat is always good service. So if you are worried about serving your qualifying tenants who need to be served under section 78 to avoid the section 79(2) sanction, take the notice inviting participation and post it under their front doors, every one of them. That is good service, because that's what it says. That must be a deeming provision.
And that is in addition to the Interpretation Act.
That's in addition to the Interpretation Act or the common law presumption of service that also applies. There is, learned friend's answer to this, he and I have had this discussion in numerous forums up and down the country. His answer to this is always, but the prescribed form says you have to name the individual leaseholder you're giving it to which I say, that's a line at the end of the notice. It's not in the Act itself. It's not even in the body of the regulations. It would be a remarkable rule if you had to give them their individual names, because at common law you don't need to name people on notices.
So what you do, just leave a letter at the flat which just says
A qualifying tenant.
to anybody who may be the
To
qualifying
the qualifying tenant, put it through. That would be good. A slight variation of that would be good for a notice to quit, because at common law you can just address it to the tenant. And we've also put, again in our written case and in the authorities bundle, we've put other statutory landlord and tenant notices where it's been held that it's good service just to say, address it to the tenant at the flat. This isn't an onerous position. This isn't some trap for the unwary. This is a really simple procedure to ensure that the people who are going to be affected by it know about what's going on, and Parliament has provided that if you don't comply with that, you cannot move to the next stage. Which then brings me... Sorry, Mike.
Just wondering how that works out. You put it through the door of the flat. The person who's in the flat has got absolutely no interest at all in passing on the post to anybody else, and the qualifying tenant doesn't end up knowing anything about it.
So the way you deal with that, one thinks about some of the service cases that have been at this court, it's then to do with where the risk of non-delivery goes.
It would quite simply be service on the qualifying tenant. But the qualifying tenant wouldn't be able to exercise any of the rights that you say the qualifying tenant would have. Because it would depend upon the notice being passed on.
But at that stage, Parliament has decided that the risk sits with the receiving party, not the giving party.
And
the giving party has done what Parliament said.
If you don't live there, if you're the qualifying tenant, you don't live there, you can always give. Well, I'm not quite sure how you give somebody else another notice, another address, if you've never dealt with this RTM company before. I mean, how do you know, if you're not living there, that an RTM company might come along and put a letter under your door addressed to the qualifying tenant?
Well, for example, suppose the first RTM claim failed. You discover about it. And
well, it might in that curious situation, but normally that would work perfectly well in relation to a landlord, but it's a bit odd in relation to an RTM company.
Possibly, but that's what Parliament has said. It's good, it is always good service to serve at the flat.
Yeah.
And if you're not living there in the flat and you haven't bothered to keep track of what's going on, you're unlikely to care whether the management has moved to the RTM company.
Quite, my lady. I'd need to address, because I haven't addressed it, it's section 84. So if I can go to page 266, please. Sorry, we're running out of time.
Yeah.
There are two short points I want to make here. The first in my submission is there's nothing on section 84 anywhere in it that says that only certain points are available to be taken by a landlord. It's governing the counter notice, and the counter notice, of course, can be given by three classes of people: landlords, third parties to leases other than as landlords and tenants, i.e. management companies or maintenance trustees under old leases, or managers appointed by the first-tier tribunal, the modern old receiver's jurisdiction.
But not qualifying tenants.
But yes. So any of those three people can give counter notices. My learned friend seems to say that there's a reason why landlords can't rely upon them, but presumably he'd have to say that the other two categories can't rely upon this point as well. Why is a third-party company to the lease not able to take this point? Why is a maintenance trustee? Why is a manager appointed by the tribunal not able to take the point? He's reading in a restriction that just isn't there.
Well, he's not saying landlords are excluded. He's simply saying no one can rely upon it who is not prejudiced by it not having happened.
I just want to be clear that is what he's saying, that with all three categories of person entitled to be given a claim notice, none of them can take this point. As long as he's happy to own that consequence.
And what would be wrong with that consequence?
It would be a surprising answer, because in the second and third category, the second category, a third party to the lease other than landlord or tenant.
Guarantor.
Well, that's most likely nowadays to be a company owned by the leaseholders. That's the modern form of this structure. A management company under the lease owned by the leaseholders. In the second category, a manager appointed by the tribunal. Well, that's someone managing pursuant to a statutory scheme in the best interest of the building. It'd be very surprising if he wasn't allowed to take the point in the best interest of the building. Now, if my own friend says it's the same for all of them, it's the same for all of them. But I just wanted to take through the implications of where he's going with that. Finally, if I can, on this one, sorry, I'm talking. Oh, I've got slightly longer. Okay, sorry, we've got slightly longer than I thought. I still need to make a bit more progress, though. Right. Finally, in this section, let's come with this bit. Yes. Parliament didn't intend non-compliance with section 78(1) to be a ground of opposition, which he touches on in the context of what section 84 lets you take. There's two answers to this in my submission. The first is the one that you've already canvassed with my learned friend. The entitlement to serve a counter notice is by reference to a specified provision of this chapter. It doesn't limit you in that way that he's arguing for. I'm allowed to argue that by any provision of this chapter, you don't qualify.
So he has to read in specified provisions, only some of which actually disentitle the RTM company.
Right.
Yes.
I read nothing in. On the face of it, your counter notice can say you do not qualify, and as long as you refer to a section that goes to qualification, then that's a good counter notice.
Or that, well, yes.
Well, goes to qualification, by which you mean qualification to
Entitlement.
transfer the right.
Yes. Yes, I do, my lord, yes.
What it calls entitlement.
Yes.
So is a fair shorthand of your point is that the provision must go to entitlement?
Yes.
Yeah. But it doesn't follow that every provision in the chapter goes to entitlement.
No, I completely accept that. A vast number of them don't. Section 96 goes to what powers transfer over. That's got nothing to do with entitlement. The second point I wanted to make with this is that I do...
There must be provisions then, which, are, as you say, have got nothing to do with entitlement.
Yes, I'm happy to show you some.
Right.
So I'm happy to show you some.
Yes.
Section 96 is the most obvious one. That's the powers that transfer over. That can have nothing to do with entitlement because it only arises once you've already acquired it. The second reason why I say he's wrong is actually a point from the legislative history. You know, when my learned friend took you to it, and you know from the other cases that have been up here on this statutory scheme, that the genesis of this is an early 2000s consultation paper, which this court treats as functionally equivalent to a white paper. We've got that paper in the authorities bundle. If we go to page 1077,
This is the same one that we have already looked at.
yes, this is the 2000 consultation paper.
Yeah. Which had a draft bill or something.
It did have a draft bill attached to it, yes, my lord. I just draw attention to what was said in paragraph 52, because in paragraph 52, the authors of the report are considering how landlords could serve their counter notices. And what it proposed is that you could only serve a counter notice by reference to one or more specific qualifying criteria.
Yes.
For example, not enough members of the company. Memorandum and articles weren't in the prescribed requirements. I find that an odd one because statutorily, if they're inconsistent, the inconsistency is deemed to be deleted and the statutory one overtakes it anyway. Or that more than 25% of the property was non-residential use. Vaguer suggestions, such that the company didn't have the skill, etc., would not be a valid one. But just over the page at 1078, they were concerned about spurious counter notices and were considering a prescribed form which sets out the grounds for objection might prevent this from happening. We'd be grateful for your views on this point. I make 2 points. Firstly, the wording of section 84 isn't by reference to specific qualifying criteria, it's any provision of this Act. And secondly, the proposal to prescribe the form which sets out the permissible grounds was not taken forward.
Well, the idea of qualifying criteria is, I think, reflected in the part of the Act headed up qualifying rules, which is section 72 to 77.
Possibly. The point I really wanted to stress was the second one. If we haven't looked at one yet, but if we go in the main hearing bundle to page 167, we have the counter notice that was served in this case. This does comply with all of the rules on form, etc.
Where's the counter notice?
167 in main hearing bundle, my lady. That's a perfectly valid notice. There isn't a for example, a tick box exercise where the draftsman's identified which sections you're allowed to rely upon and you tick one to say. You just have to complete the text after I allege that by reason of, and then you specify the sections. So
just as a matter of information, in relation to paragraph 2, did Avon have that information at the time that the notice was served, or is this a standard, you know, put everything in and see what turns up?
I can't, despite being counsel in the FTT, I'm afraid I can't remember from all those years ago. I suspect they had enough information.
Right.
We haven't got, I have got sitting in my room in Chambers all the correspondence from years ago about backwards and forth on this.
So is the 78.1 point, in effect, the 79.2 point?
Yes. You didn't comply with section 78.1. That's the provision you didn't comply with. But the point I wanted to make was this. My learned friend prays in aid the proposition that Parliament didn't want this to be a route for obstructive landlords, etc., etc. I agree. And they turned their minds to how you might limit the grounds of opposition, including possibly having a prescribed form that would set out what you were allowed to object on the basis of. That's not what they did. They simply said, by virtue of a specified provision of this chapter. So when my learned friend asks you to read words in, or to read a gloss, or to give effect to a particular interpretation, he's asking you to do something that was clearly mooted and not carried forward. My learned friend then says Parliament didn't intend failure to serve the NIP to have such extreme consequences, when failure to serve a claim notice does not. But the answer to that is because in A1 properties, it was held that you can apply a synergy analysis, because the failure to serve a claim notice doesn't have an equivalent to section 79.2. So if we look back in the Act, at section 79 on page 259.
If you're right, and it is a ground on which a counter notice can be served, the tribunal's jurisdiction is thereby properly invoked. The tribunal says, yes, you're right, Miss O'Connor should have been served but was not served. Does that preclude them from then granting the right to granting the management right, or what are the powers of those?
So in those circumstances, in my submission, its only choice is to dismiss the right to manage claim and to hold that on the relevant date, the RTM company was not entitled to acquire the right to manage. And then its reasoning should be, in my submission, that having failed to give Miss O'Connor the notice she was entitled to receive under section 78.1, that means it was that the subsequent step of giving the claim notice under 79.1 was not possible because of 79.2. So what has been given is not a claim notice sufficient to transfer the right, albeit it is a claim notice sufficient to engage the tribunal's jurisdiction.
And that would be so whether, as here, a person wasn't served, or a person was served but only 13 days before the claim notice.
So long as they haven't joined the company by the relevant date.
Yes.
Yes.
Yeah.
Yes, I accept that. I don't need to win that second point to win the appeal, of course.
No, but you may need to address it to see if we can come up with a coherent understanding of how section 79.2 works.
To which the short answer is the answer I was
Yes.
having my Lord Snowden. There has to be a time limit. Parliament's chosen that one. But if you look at section 79, back on page 259. The reason why we moved to a synergy analysis in A1 properties is because nowhere in section 79 does it say anything about what happens if you fail to serve a particular class of landlord. There isn't an equivalent of 79.2 that deals with a failure to serve a landlord under 79.6, which is where the duty to serve landlords comes from. And in my respect to the mission, that's important to understand because that's why this court held what it held in A1 properties. This court rejected the argument from me that the word must in 79.6 shows it has to be complied with. And said, well, of course it has to be complied with. Parliament says it has to be complied with. But that doesn't help you with what happens if it isn't complied with. You then go in A1 properties to subsection 81.1, because I argued, well, that shows that some flaws must be fatal because they've saved others, and the court said no. All that shows you is that Parliament has worked out what it wants the consequences of some flaws to be. It doesn't help you with the question in A1 properties, which is whether or not the failure to serve a landlord ends the whole process. And then we go back to what this court said in Synergy all those years ago. If Parliament hasn't specified the consequence, and it hasn't, we have to come up with a conclusion that best fits Parliament's intent, looking at the scheme of the Act as a whole, the facts of individual cases, etc., etc., etc. The usual Synergy analysis, disapproving the approach that had been creeping into the Court of Appeal with cases like Nat and Osman. But none of that arises here because there's no equivalent of 79.2. Consider in A1 properties. This is all 79.2. If 79.2 doesn't have the effect that I contend for, it's a synergy case. That's what this court decided in A1 properties. If it does have the effect I contend for, then unless my learned friend's right that it's a point that my class of client isn't allowed to take, it's fatal. So it all turns on 79.2. Is that a consequence? If yes, is it a consequence that can be taken by my client? And for the reasons we've given, hopefully made sense, even if not always finding favour, it is a consequence. If you start the process by giving the notice and then you're told you may not give it, that is what flows from it. Is there some reason why we can't take it? Well, what do we have to read into Section 84?
Struggle, apart from just saying this is what Parliament meant, said, I struggle to see, well, I've been struggling to see what the benefit for the qualifying tenant is, and I struggle even more to see what the benefit for the landlord is, or the disadvantage to the landlord if the NIP isn't served on one qualifying tenant.
Well, the one... there's two answers to that, my lord. The first is, respectfully, I say that's the wrong question. Because by getting to that question, you're implicitly going into a synergy analysis of trying to weigh up what Parliament intended the effect to be. We start with the plain words, and that's why, accepting my Lord Rees' point that Shaheed is a very different context, that's why paragraphs 20 21 of Shaheed matter. You start with the words. If the words are clear, then that's what we have to give effect to, and no amount of purposive interpretation can help you. As to why landlords should be able to...
Looking at the purpose, what is the purpose as far as the landlord is concerned?
So, the landlord, it seems to me, has several points they could make. The first is that Parliament entitles them to take this point because it hasn't excluded it in Section 84.3.
With respect, that doesn't answer the purpose for the landlord. That just says Parliament said it, and therefore it must be so.
Well, if Parliament's provided for an entitlement to take the point, it must, in my respectful submission, be intended that landlords can take the point. But what do landlords get from this? Well, what landlords get from this process, from proper compliance with the statutory scheme is not having to engage with the incredibly difficult questions we've been looking at this morning about borderline cases, and do they go through on waiver, do they go through on estoppel, do you end up in the High Court on void and voidable? The way this scheme will work is when it goes through is the landlord simply has to get rid of all his cleaners, get rid of the gardeners, at least the marketing company takes over. He's got to give over all the service charge funds. Could be lots of money in the reserve fund he has to give over on this purpose. This is one point where I do agree with my learned friend that there's a real value to that certainty. Knowing Parliament has set up a process. If that process is followed, the landlord has no choice but to give over both his powers...
I can well understand the practical implications, but the question I was asking was slightly different, and that is, when you're interpreting section 79, subsection 2, and you look for the purpose for making sure that the landlord has an interest in the NIP being served on all qualifying tenants, I still struggle to see what the purpose is.
My Lord, I'll answer it straight away then. The purpose is, by knowing that they've all been served, the landlord knows that he won't face the kind of problems that this court grappled with in paragraphs 87 and 88 of A1. These situations about people subsequently coming along and threatening to void the process. He knows he can hand over management and step back. Because on my learned friend's case, what actually happens is that the RTM passes over, so they get given all the service charge money, their cleaners go in, they're the ones repairing it, they're the ones who are now engaging with all the fire safety duties, whatever the case may be. But conceivably, 3 years down the line, someone might come along and void it, whereupon everything falls back to the landlord to deal with. The landlord gets the certainty. The landlord gets the certainty of knowing that the kind of problems that this court has grappled with in A1 in paragraphs 87 and 88 won't arise. That's why it matters to landlords. No one is going to come along down the line and say, why haven't you been managing this building? They're not a proper RTM company. That's the certainty. It enables them to drop out of the picture.
– 87 and 88 were really about the problems that arise from a synergy analysis. That if the notice is voidable, then there are liable to be that's a cause of uncertainty because somebody can pop up and seek to have it avoided.
Yes. And that's what my learned friend is arguing for. And there's no getting around this. If it's a synergy analysis in a property law context, 87 and 88 must be right.
Yeah, well, I thought well, forgive me, I thought we had perhaps moved beyond the voidable analysis.
But it was my answer to my Lord's question, what does the landlord get? He gets the advantage of knowing that the, frankly, very expensive and quite risky procedures that are discussed in sections 87 and 88, paragraphs 87 and 88, will not come back and bite him. He hands over management, step back, he has nothing to worry about.
But a conclusion that within the meaning of section 84, compliance or otherwise with notifying qualifying tenants didn't go to entitlement would create the same certainty for the landlord, wouldn't it? Because it wouldn't be a valid ground for serving a counter notice. Therefore, either if you did serve a counter notice, you get thrown out in the first tier tribunal, or if you were sensible and didn't serve a counter notice, the scheme would just go through.
Yes, it would. Yes, a conclusion that the landlord can't take the point would do exactly the same thing.
Yeah.
That grapples back to the same problem, though, as to what words one implies in, and the point I was making, I'm not quite sure it landed, but it has to apply to all of the 3 categories of person who can be given a claim notice.
Oh, yes.
I struggle with that as well, unfortunately. I mean, what difference does it make at all to a guarantor that one tenant hasn't been served with a NIP?
So it's merely one. So a guarantor would really be one example of it. The 2 categories I'm worried about. The full wording is a person who's a party to a lease other than landlord or tenant.
Sorry?
A person who's a party to a lease other than as landlord or tenant. Guarantor is an example, I accept, but so is a lessee-owned management company, which is the common way of doing these things. They need that same certainty because they do the management in place of the landlord. And the other category...
So
Sorry, my lord.
So a lessee-owned management company
Yes. So in the
would have a right to say, I'm terribly sorry, there's one qualifying tenant that hasn't been served.
Yes.
That's the end of that.
They have
And what's the benefit for them?
the same as for the landlord. They're the people that do the management. So they get the claim notice.
Yep.
They say, oh, you're about to oust us.
Yep.
We won't have access to the service charge funds anymore. We can't run the building. So we're losing that right. But it looks like you didn't serve one of these people.
Yep.
So if the right to manage transfers over, then absent my Lord Briggs's suggestion,
Yep.
they face the same danger the landlord has, which is someone might come along years later and unpick it.
Yep.
For the third category of person who gets a claim notice, which is a manager appointed by the tribunal under the Landlord and Tenant Act 1987, which in very simple terms, as I said, is the modern equivalent of the old receiver's jurisdiction, essentially a fault-based... The landlord's been bad, and a surveyor is brought in to run the building in the best interest of the building. He has a real interest as well, because he's managing pursuant to directions of a court or tribunal, pursuant to a statutory scheme, and he needs to know, can I step away? Can I apply to have my appointment discharged?
Yeah, well, that's the same as the landlord.
Exactly. It's the same for all of them. But it's the same categories for all of them. I fully appreciate that there may be a reluctance to step in to save landlords. They're not the most sympathetic category of litigant that comes before courts. But the problem with my learned friend's argument is it also captures other categories of person whom it's harder to see why Parliament would be more relaxed about their rights being infringed.
Can I ask you a question about
Yes,
the contents of the claim notice, which is set out in section 80? So this is what the landlord receives.
Yeah.
And there's a detailed set of specifications there. One of the critical things that gives rise to the right to manage is that the numerosity requirement, I think, isn't it, in section 79.5,
Yes.
that the membership of the company must on the relevant date include a number of qualifying tenants which is not less than 1/2 of the total number of flats. But in relation to that, if the claim notice gets it wrong, because it states that people are members but they're not qualifying tenants, it doesn't matter, provided you've got a sufficient number. That's section 81.2.
I agree, my lord, yes.
And we've already seen section 81.1 says any of the particulars can be inaccurate in any respect. So it seems odd that landlords can pretty much receive completely inaccurate information in the claim form about everybody that they're actually interested in, that underlies the right to manage. But for some reason, what you say is critical is that they have to, or they can take the point that somebody in whom, by definition, they're not interested, somebody who's not a member of the RTM company, hasn't been sent a notice of intention to, an invitation to participate. Why is that? I mean, why does Parliament give, on your argument, landlords a critical right to find out about people who they're not interested in because they don't give rise to any entitlement against them, but in relation to virtually every aspect of the people they are interested in, it doesn't matter how inaccurate the information they get is?
It's not that it doesn't matter how inaccurate it is. What Parliament has said matters is that so long as you, in fact, have sufficient numbers to meet the statutory threshold, nothing else matters. That's what 81.2 is doing.
Yeah, and people who, by definition, the people who are not members of the RTM company on whom you are supposed to serve the notice, the invitation to participate, they're not the people the landlord's interested in terms of whether the actual right has been triggered against them, against the landlord.
Well, the landlord is interested to know whether what has been served is a sufficient basis to transfer the right to manage. Because, of course, if the claim is...
So he's interested in making sure that the members of the RTM company comprise at least 50% of the flats, the qualifying tenants of at least 50% of the flats.
I think he's interested in a bit more than that. He's interested in knowing, in my submission, he's interested in knowing which of the three options Section 84 gives him should he take. Can he safely admit the right to manage? For example, he might be prepared to. But if he's worried about the consequences of admitting because he's worried someone hasn't been served, he can instead serve his negative notice. The assumption is that landlords are all going to oppose this. And I know that that's what comes to court, but that's not how the scheme works.
But
the scheme works on the basis of he has to make one of the three choices.
I understand why landlords would want to know that the right to manage is being validly exercised against them. And for that purpose, they have to know that the members of the RTM company comprise the qualifying tenants of more than 50% of the flats in the block. The one set of people they aren't by definition interested in, because that is the test, are the people who are not members of the RTM company.
No, they are interested in them. If those people who are not members of the RTM company and who were not given the NIP, they are the ones, on my learned friend's argument, who would be doing what this court looked at in paragraphs 87 and 88 of A1. They're the ones who will be challenging the RTM down the line. But they'd be the ones then, they're the ones who will be continuing to expect the landlord to do things. So the landlord needs to know that the RTM company is going to repair the roof. The people, he needs to know that all of the leaseholders are bound by that. He doesn't want a situation where one leaseholder says, they are not a valid right to manage company. There is a leak in the roof, it's causing damage to my flat, here's my claim for an injunction and damages of £5,000. That's why he needs to know there's been compliance with the scheme. And where the scheme says that all of the individual leaseholders have to be given their notice beforehand, that's why he needs to know it's been achieved. Because he can't have a situation where one of those people who wasn't served 2 years later comes along and says, you're still the person responsible for all the covenants under the lease. You're still the person who should be managing. That's why it matters
but
to
if that was so, you really would think that Parliament would have required a statement in the claim, in the claim notice, as to who has been served with the NIP, because he's only got, I think, a month to put in his counter notice.
Yes.
And in a big block with, say, 1,000 qualifying tenants, the idea is going to be able to find out who has and who hasn't been served. I mean, okay, this is a small flat, you found out. But the idea that in a big flat situation, the landlord gets the information he needs to find out whether to take a no service of NIP objection seems to be almost fanciful. Unless, as I say, the notice, which it doesn't, was required to spell out who's been served with the NIP.
No, but what it does tell you, the notice, it does have to tell you who the members of the company are.
Oh, yes.
So you immediately know who you're concerned with, which by definition will be at most...
You know who your qualifying tenants... Well, you may know who your qualifying tenants are, subject to legal uncertainties and registration problems. What you won't know is who's been served with the NIP, which it would be the easiest thing for the statute to have required the RTM company to say so in the claim form.
But I agree, but respectfully, that's not the answer to what Section 97.2 means, nor to whether you can take the point under Section 84. That's an example of why parliamentary draftsmen sometimes doesn't achieve perfection.
No.
it all keeps coming back in my submission to those two narrow questions I started with. What is section 79.2 actually doing? It must be doing something. Why isn't it doing what its plain words mean?
Now, Mr. Bates, it's a matter for you, but I'm conscious that we're rapidly running out of time in which Ms. Gibson might be able to address us. And I think you are planning to...
I'm very grateful for that for that reminder. As much as I was enjoying myself, it's very important that I do pass over this issue to Ms. Gibson. So this is the waiver issue that my learned friend opened in outline but ran out of time to deal with.
Yes.
The way he put it in opening was that there was a waiver of the right to receive the notice, and I'm going to ask Ms. Gibson to deal with that.
Yes, of course. Ms. Gibson, I'm afraid you've been left with very little time, but we're delighted to hear you, and you've got about 5 minutes.
Thankfully, it's quite a short point, my lord. Essentially, it formed no part of the appellant's case in the FTT, being the factual finder in this case, that there was a waiver of any sort. And to make that point good, the application form is in the bundle. We didn't turn to it, but it's at page 169 to 177. There's nothing in that form regarding Miss O'Connor was aware of this right. Nevertheless, she chose not to receive the NIP, such that we then deliberately didn't serve her with the NIP. The first time that the substantive issue of Miss O'Connor arises is in my client's pleading. Now, the relevant paragraph is at page 181 of the main bundle. In paragraph 29, where the respondent raises that from a view of the copy notices, it does not appear that a notice about participation was served upon a qualifying tenant of flat 17. So that is the first time that flat 17 arises. And then the appellant's pleading and response can be found beginning on page 193. But the relevant paragraph is paragraph 30 on page 200. Now here it's conceded that no NIP was given, for the reason they say a leasehold title entry is not registered at the HM Land Registry for this particular flat, and therefore no qualifying tenant exists. Therefore, they didn't need to serve her because she is not a QT. If the applicant is wrong on this, then the applicant will rely on a consent form completed by Miss O'Connor agreeing to become a member of the company and noting her liability as a member. That is to say, because she had agreed to become a member, she didn't therefore need to get...
Sorry, I'll stop. Put that one too.
It's all right, thank you. Yeah.
So make sure you stay between here. Thank you. I'm here all night.
Essentially, she didn't need to be served. She either consented and had agreed to be a member, or she wasn't a qualifying tenant. However, this consent form, again, you shan't turn to it. It can be found on page 212, and it's dated the 26th of January. That is 5 days after the claim notice was served on the 21st of January, 2022. So it post-dates the relevant date, and the relevant inquiry is on the relevant date. Had that individual joined the RTM co or agreed to. So the consent form doesn't achieve the purpose that the applicant gives it. And as this transpires in the FTT, that's in the key documents bundle beginning on page 148. Particularly paragraph 19 on page 154. The applicant repeats the point that we didn't need to serve the leaseholder of that 17 because she was not a qualifying tenant.
And that was argued, wasn't it, up to in the FTT and the upper tribunal?
Yes.
Yeah.
In the UT, I made the submissions on that, and then in the Court of Appeal, and this court didn't give permission for that issue to be argued again. And additionally, at paragraph 30 on page 158, there again the applicant's argument is put. This is the alternative, based on the consent form. Now, in the penultimate line there in the brackets, we can see that this argument regarding the consent form we didn't need to serve her was not raised again by them at the hearing. So seemingly then the argument had been dropped. There's nothing in the FTT decision or the applicant's pleadings relating to Miss O'Connor having been aware of her right to be served but nevertheless chose not to. And quite how that could have been the case when the applicant had argued we didn't need to serve her in the first place begs the question. Neither is there any evidence from Miss O'Connor in a witness statement or the like reciting these points, or from the RTM code that therefore they deliberately didn't need to serve her with the NIP. And the reason I make these points as the ingredients for waiver is because they come from the judgment of Lord Diplock in the Cummins Ballrooms case, particularly at page 1154 of the authorities bundle. That is the main bundle. Because there is no evidence of any promise or reliance or representation from Miss O'Connor that you needn't serve me, there's nothing that possibly could have been said by the RTM code to rely upon that, such that Miss O'Connor therefore waived her right to be served in the first place. And a consent form which post-dates the relevant date can't achieve that objective either. And there is one very final short point relating to, even assuming it had been pleaded, assuming there was evidence in the first place, as a matter of law, could Miss O'Connor have waived this right to receive the NIP? And the answer to that is no. The reason being the principle from the Johnson and Morton case, which, for the court's note, begins at 588 in the bundle, the main docs, but the most relevant part can be found in the judgment of Lord Hailsham on page 609. And I quote, "A person may renounce a right that exists solely for his own use or benefit. If there is a public as well as private interest, one cannot waive that right." So then we have to ask ourselves whether the requirement to serve Miss O'Connor with the NIP was solely for her benefit, or is it a mix of public benefit and private benefit, or perhaps solely public? Well, the answer is no, it can't solely have been for her benefit. The requirement to serve an NIP is a benefit to be conferred on all leaseholders where an RTM claim is to be pursued, all members of Cresta Court in this case. It prevents someone from being excluded from decisions about the management of their home. And there's a benefit to the RTM company as well, being a different person from Miss O'Connor. The more members you have following the service of the NIP, the easier it is to show that you meet the qualifying criteria of having enough members on the relevant date. And even more simply, the more members you have, the more people there are to do the work required of the RTM company. So it's submitted then that even if there was evidence, it had been pleaded, there was a factual finding to the effect. As a matter of law, Miss O'Connor could not have waived that right to receive the NIP prior to being served with the claim notice.
So would you say that if we are of the view that Section 79.2 is a provision that a RTM company can specify in its counter notice as disentitling the RTM company from giving a claim notice, we must have decided that the landlord or one of the other two categories has some interest in that provision being complied with, and therefore it cannot be that Miss O'Connor can waive her right in a way that affects their ability to rely on that provision in a counter notice.
That's another example of a benefit to someone other than Miss O'Connor, but I wouldn't say we need to go that far. It's of obvious benefit to the RTM company that there be more members. I would agree with my lady's point. Unless I can be further assistance, I'll return to Mr. Bates.
Thank you very much, Ms Gibson.
My lord, my lady, unless we can help you any further, those are our submissions.
Thank you very much, Mr Bates. Mr Jacob.
Try and make sure these are lined up. Yes, a few points to respond to. So, before lunch, my old friend Mr Bates gave some examples of 10 flats in a block, and he said 5 are members, 5 are not members. He was discussing a landlord who receives the claim notice, and on that date when they receive it, they have to make an assessment of whether Section 78 has been complied with. And he gave some examples where he said that would be okay because the qualifying tenants have become members prior to service of the claim notice, an example where it wouldn't if they hadn't become members by that time. One thing he's really failed to meet is the point that the landlord doesn't have the information to make this assessment. They get the claim notice and they haven't got a clue whether the 5 people who should have been served with the notice have been served or not, the participation notice. The question posed to Mr Bates was how the landlord found out in this case, and Ms Gibson's submissions actually showed us the reference in the statement of case, page 181, paragraph 29, as part of the assessment of the claim notice, given the respondent requested evidence of service of the notice invited participation in this matter from review of the copy notices supplied. The landlord in this case then picked up on what it saw as a fatal flaw in the process. In this case, therefore, there was a voluntary disclosure of the information by the right to manage company. I can only speculate as to why, I don't know, but it may have been because they thought they complied, because at that stage, as you can see, they believed they didn't need to serve this tenant. But they had no obligation to provide that information. The scheme doesn't require them to, so in other cases, if the right to manage company does not provide the information, the landlord cannot make the assessment that Mr Bates says they should be entitled to make on the date of receipt of the claim notice. So, if he's right in his interpretation of the statute, it does very much encourage speculative objections by obstructive landlords. They will not know whether it's been complied with or not, and they'll simply put in their counter notice and they'll say, we allege that you haven't complied with Section 78(1). It will have to go to a tribunal then. If the company, the right company, wants to gain the right to manage, they have to apply to the tribunal for a determination. If they don't, the statutory procedure results in the deemed withdrawal of their claim notice, so everything stops. So upon receipt of the counter notice, they have to apply to the tribunal. Then what the obstructive landlord can do at that stage is say, well, now we're in the tribunal, you must demonstrate to the tribunal that you qualify for the right to manage for it to make the determination. So you prove to the tribunal that you served the notice inviting participation. So that's where this goes if this is the correct interpretation the respondent puts forward. The obstructive landlords just take a speculative objection, they see where it goes. Even if the company is complied and it goes nowhere, simply putting in the claim notice, the counter notice, forces the right to manage company to make the application. It postpones the acquisition date. They get stuck in the tribunal process, and it can delay matters by a number of months at the very least. So there's still incentive for an obstructive landlord to put in a speculative counter notice to try and delay matters and keep the management in their control for as long as possible. But it really does demonstrate in my submission why Parliament cannot have intended this to be a point that would be taken by landlords. How come there is no mechanism in the statute to enable landlords to ascertain whether they can take the point? My own friend dealt with a point about difficulties in compliance. So the point is, he says, why is it difficult to comply with this? All you need to do is rely on the deemed service provisions on qualifying tenants by delivering notices to all the flats in the premises. And on his argument, one can simply address it to the qualifying tenant in all the flats, and therefore there is compliance. My submission, that would be unacceptable in terms of the statutory scheme that we're dealing with. It wouldn't comply with the scheme. Perhaps I could just quickly run through some provisions. So, page 257, we have section 78(1). For making a claim to acquire the right to manage any premises, a RTM company must give notice to each person who at the time when the notice is given is the qualifying tenant of the flat, etc. The reference to each person, my submission suggests an individual person, whether an individual or corporate, rather than just addressing it to the qualifying tenant, whoever that may be, rather than addressing it to the class of individual. Section 78.3 has a requirement for a form of notice to be used. So a notice of invitation to participate must also comply with such requirements, if any, about the form of notices of invitation to participate as may be prescribed by regulations so made. There is a form. In the main bundle, you have the 2010 regulations with the form. Hopefully, the court has the supplementary authorities bundle from the appellant, which has the 2003 regulations.
Yes.
So those were the ones that came into force at the same time as the 2002 Act came into force. And in the supplementary bundle, there's also an extract from the PACAR in Competition Appeal Tribunal case, just to make the point that, as Lord Sales says at paragraph 45, so that's page 9 of the supplementary authorities bundle, between G and H towards the bottom of the page, paragraph 45, where the primary legislation and the subordinate legislation are drafted by or on the instructions of the same government department at about the same time, as would be normal in this type of case, it's reasonable to suppose that they are inspired by the same underlying objective and are intended to reflect a coherent position as understood at the time the primary legislation is presented to Parliament. In that situation, it's been observed that the subordinate legislation made under a power in the primary legislation can be regarded as a form of parliamentary or administrative contemporanea exposito, i.e. exposition of contemporary understanding in relation to the primary legislation, which may provide some evidence of how Parliament understood the words it used in the primary legislation, even though this does not decide or control their meaning. So we have here the 2003 regulations. They come into force at the same time as the statute on the 30th of September 2003. If we go to page 14 of the supplementary bundle, paragraph 8.1, notices of invitation to participate shall be in the form set out in Schedule 1 to these regulations. Note it does not have a wording which sometimes appears to say or to the similar effect or substantial effect. It simply says in the form set out in the schedule. Page 15, the requisite form of notice of invitation to participate starts off saying to square brackets, name and address, close square brackets. So it indicates in the form that one provides the name and address of the relevant qualifying tenant. It could have said to the qualifying tenant, but it didn't. It said name and address. It presupposes the name is known. And in my submission, I can't take the court to this through lack of time, but there are two authorities referred to by the respondents on this point. They appear at page 77 for your note in footnote 16 of their written case. One they have is O.G. Thomas and Turner to make the point that the common law does not require a notice to quit to contain the name of the recipient. In relation to that, just briefly, that concerned a notice to quit under the Agricultural Holdings Act 1986. And for your note, page 671, paragraph 11 of the judgment, confirms that a notice to quit under that act did not require a prescribed form. So it's different to the situation here where we have a prescribed form. Second point, page 675, paragraph 29, makes the point that even at common law, where you have to identify the person by name, you must correctly identify the person. And here we have an obligation to identify the person by name. The second case is Leasehold as a founding court in London Borough of Camden, relied on by the respondent. There, the point they make is to say other landlord and tenant statutes are satisfied by sending a document addressed to the leaseholder. The point about that, again, it's a case relating to requirements to consult tenants before major works and then recover service charges. Just for your note, paragraph 71, page 638, makes the point that the 1985 Act does not require notice by name. So again, it's distinguishable. My learned friends rely on cases where there was no requirement for notice by name. Here we have a form that requires that. There is a clear risk of problems if one simply says to the qualifying tenant, because we have no residence condition within this statutory scheme, so one can be the qualifying tenant and let one's flat out on an assured short tenancy. A document turns up at the flat saying to the qualifying tenant. Firstly, there might be a redirection scheme in place which might redirect things if it was addressed to whoever the actual non-leaseholder is, but it's unlikely to redirect something just addressed to the qualifying tenant. Secondly, the occupational tenant may either disregard it because they can't see the name of their landlord on it to know to send it on to the landlord, or they might even open it, think it was addressed to them, and decide they don't want to participate because the assured tenant may not realise they're not a qualifying tenant because they don't understand what that concept means. But there are risks of this not getting through to the qualifying tenant. And my learned friend is right to say that Parliament can make a choice as to the risk of non-receipt. When it has a deemed service provision, there's obviously a risk of non-receipt, and Parliament makes a choice as to that. But it's one thing to say, if it's addressed to the correct person, they take the risk, they don't receive it because it goes to the flat. It's another to say, well, it's addressed just to this description of class of people qualifying tenant, and they still take the risk if that doesn't get through to them, that they're stuck with deemed service. And finally, unless this court makes it very clear it can be done, if right to manage companies did address it to the qualifying tenants and sent it to all the flats, landlords such as the respondent here would rely on that, and they would make the counter argument and say, well, the form says name, and we would be running this through the tribunal. So unless there's a clear decision by this court that it is an acceptable course of action, that's simply another alleged breach or breach that the landlord can rely on to try and obstruct acquisition in future. Moving on to a different point, just about specification of the consequences of non-compliance and whether that's what section 79.2 does. My learned friend refers to 3 cases in the written case, one of which he took the court to, the Shahid case. So page 1020, paragraph 15 that he referred the court to, there it sets out the relevant provision being considered there in relation to segregation. And in the quotation in paragraph 15, a prisoner shall not be subject to such removal for a period in excess of 72 hours from the time of the order, except where, etc., etc. The analysis there was that the words shall not be subject to such removal except mean that what follows is a precondition to lawful segregation. So effectively the analysis there was therefore that wording itself had created the consequence, effectively. One couldn't analyse what would happen if you breached that because the consequence is specified within it. If it says you shall not do something except, you can only do it in those circumstances. But it's interesting to compare this to the wording in Soneggi, where we get the current modern view on interpreting the consequences of non-compliance, where Parliament hasn't specified the consequence. Perhaps I could just quickly show the court what was in Soneggi being considered. It's page 857. And within there it's section 72A of the 1988 Act and section 72A3. We can see there it says, unless it is satisfied there are exceptional circumstances, the court shall not specify a period, etc., etc. It's a similar sort of wording to what was being considered in Shahid, shall not except, unless shall not. But in Soneggi, it wasn't considered that this in itself specified the consequence if there were no exceptional circumstances, but nevertheless the court specified a period beyond that which was allowable. What happened? In Soneggi, the House of Lords considered an open question, rather than saying, well, it's obvious, it specifies its own consequence within the wording. So I suppose what I'd ask you to take from this, that it's perhaps statute specific. Each statute has to be considered on its own terms, in context of all the relevant provisions and its statutory purpose. In the Shahid case, considering that in context, yes, it specified its own consequence. There was no synergy analysis available. In synergy, that was not the approach taken. So in this case, when this court is construing section 79.2, it's not simply the case that one says, well, it specifies the consequence. Actually, it's more nuanced than that. You may take the view that, no, it doesn't specify the consequence of what happens if you serve your claim notice despite having not served all the notices of invitation to participate. So that does lead you to, it can lead the court to an analysis which rejects that of the Court of Appeal and concludes that actually this doesn't enable the landlord to object to acquisition and doesn't compel the conclusion that the right to manage scheme is fatally flawed and has to be restarted in this case. Perhaps I can just briefly deal with waiver. So, for waiver, the respondent sets out a test for what the respondents say is the test for waiver, relying on the Cummins Ballrooms case. So, page 1153 to 4. So there's actually two types of waiver discussed in that case. So if we look at 1153, the last paragraph, Lord Diplock says, so it becomes necessary to consider whether the respondents did waive this requirement. Waiver is a word which is sometimes used loosely to describe a number of different legal grounds on which a person may be debarred from asserting a substantive right which he once possessed, or from raising a particular defence to a claim against him which would otherwise be available to him. We are not concerned in the instant appeal with the first type of waiver. This arises in a situation where a person is entitled to alternative rights inconsistent with one another if he has knowledge of the facts which give rise in law to these alternative rights and acts in a manner which is consistent only with his having chosen to rely on one of them. The law holds him to his choice even though he was unaware that this would be the legal consequence of what he did. He is sometimes said to have waived the alternative right, and it gives an example of forfeiture. The next paragraph, the second type of waiver which debars a person from raising a particular defence to a claim against him, arises when he either agrees with the claimant not to raise that particular defence or so conducts himself as to be stopped from raising it. This is the type of waiver which constitutes the exception to a prohibition such as that imposed by section 29(3) of the Landlord and Tenant Act 1954 and other statutes of limitation. Now, so in this case, the court was concerned with a provision in the 1954 Act that gave a time limit on when a tenant must apply to the court for a new business tenancy. It couldn't be made too early or too late, the application, and the question was, had the landlord waived their right to take objection to an application that was made at the wrong time? So that was the second type of waiver being discussed, and therefore there had to be consideration of a estoppel or acquiescence was also considered an option. But in this case, in my submission, we're actually dealing with the first type of waiver, not the second as contended for by the respondent. We're not here concerned with a party raising a defence to a claim. There is no claim against Miss O'Connor. She has no defence to raise to a claim. It is simply a statutory right to receipt of a notice and the question whether she has waived her right to receive it. So the position is akin to the first class of waiver referred to by Lord Diplock. In my submission, qualifying tenants should be able to waive a right by a unilateral act. There is no need for there to be reliance by another party or some form of estoppel.
But so are you saying that every time a tenant who was not properly notified when they should have been joins the company as a member, they've waived their right to be given the NIP? Or is that itself a waiver, or what more do you need?
Every case will have to be determined on its own facts. In this case, I say there are two factors that justify the conclusion that she has waived. One is joining the company. So she has signed a form, not only joining the company, but it goes further than that. She has agreed to support the claim to acquire the right to manage. So, sorry, I just need to find the consent form. I believe it's page 2 212. So there, the consent form at 212 has a number of statements confirming various pieces of information. The second one saying I/we says I/we support the proposal to engage the services of the RTMF to act for leaseholders, to form a right to manage company and process a right to manage claim. So after the claim notice has been served, a few days after service of the claim notice, she signs this consent form with these various statements, including expressing her support for the proposal to acquire the right to manage. That's one factor. And the second factor is, as observed by the upper tribunal, she has not sought to challenge the claim notice in any way at any stage.
One of the basic principles is that you have to, first of all, allege and then you've got to prove. And so one of the points taken against you is that there was no such allegation and and the evidence didn't address it.
Yeah, so on the respondent's case, we would have to be proving some form of estoppel, and so perhaps we'd have to go through alleging and proving certain elements. My submission as to what the test is, we simply need to have some facts from which waiver can be established. On the facts, the undisputed facts that are before the court, in my submission, there can be a finding of waiver, and there doesn't really need to be any evidence on this matter beyond the two factors I have given. We know the consent form she signed, and we know she has taken no objection. That beyond that, in my submission, we don't need any more evidence.
But hadn't the claim notice already been put in?
The claim notice had been put in, yes.
Yeah, so that's rather different. I mean, it's a done deal then. She might think, well, I better join. Don't want to be seen to be free riding on everybody else. But is she really waiving the right that she had to be told about it before the claim notice was put in?
Well, there's also the lack of any objection to the failure to serve her. So there's two aspects. No action by her to make any challenge to the failure to serve her, and signing up, not only to be a member, but also indicating agreement to the process of the right to manage claim. So she's not signing up to try and obstruct it or to try and change people's views, lobby them. She simply wants it to proceed. I don't propose to say any more about that. It's only an alternative argument if the main argument fails. I think I have 3 minutes left. I could probably just make one final point. Just as regards the purpose of the notice inviting participation, it is wholly for the benefit of the qualifying tenant concerned. It's not for the benefit of the landlord. So Mr. Bates, his key point was the landlord gets certainty of knowing that no one down the line will seek to avoid the process. Well, on the facts of this case, they have the certainty because we know that Ms. O'Connor won't be seeking to avoid the process. She wants it to proceed. But this all depends, ultimately, my learned friend's argument, on this court concluding that if there is a failure to serve a notice inviting participation, the effect is that the tenant who's not served has a right to avoid the process. And as was suggested earlier by Lord Reid, maybe that is not actually the consequence. It's what the upper tribunal thought might be an appropriate consequence. And the reason why the upper tribunal arrived at that was because of looking at A1 properties and seeing how the Supreme Court had given some guidance as to what could happen. But this court can conclude an alternative in the case of a notice inviting participation. This court may conclude that actually the tenant doesn't have the right to avoid it. If that conclusion is reached, then that would create the certainty that my learned friend seeks to rely on. One must also not forget that we're dealing with a position where the qualifying criteria have been established in a dispute in front of the FTT. We have a situation here where the FTT concluded the premises qualified despite the landlord disputing that. Membership requirements were addressed sufficiently despite the landlord disputing that. And so everything is covered. It is a valid claim subject to one procedural breach. That's all that's left, just to say, well, because you didn't serve this notice, this is invalid, you have to start again. And actually at this stage, we don't need to serve that notice because she's a member.
On one view, you can get to the same result through Section 84, and that is that the landlord has not got any entitlement
Yes.
And,
I think you were suggesting that was the alternative to the avoidability route.
Yes.
Yes.
Yes. And that is actually what this court, well, yes, so this court held no when properties, the landlord cannot rely on failure to serve another landlord in a counter notice.
Yes.
So the landlord who receives it can't say you didn't serve somebody else in breach of section 796, because that's not an objection you can put forward. That's what A1 Properties makes clear. So if you can't object because another landlord wasn't served, it's not a big leap to say, well, you also can't object because a tenant wasn't served, which is even more remote to your position in a landlord serving a counter notice. So why can't we make that next logical step in the process as to what actually are they entitled to object to? And it should then bring the focus back to landlords enforcing what should be relevant to them. Do the premises qualify? Have the qualifying criteria been established? And not with my learned friend's approach, which puts enforcement or waiver of a qualifying tenant's rights in the hands of the landlord. And just as a final point, I'd suggest Lord Justice Lewison put it aptly in Ellen Court. The reference, page 527, paragraph 63, made the comment, it's quite unrealistic to view a landlord who fiercely resists the acquisition of the right to manage as being in some way the guardian angel of the qualifying tenants. So they shouldn't be, and this appeal should be allowed. So unless there's anything I can assist with, I think I've come to the end of my time.
Thank you very much, Mr. Jacob. Well, we're very grateful for the clarity of the submissions we've received on both sides. It's really been very helpful. We'll take time now to consider all we've heard and let you have our decision in due course, which I think will probably be early in next term. Call will adjourn.